Thank you, Mr. Chairman, and thank each and every one of you for being here this afternoon. This is a pretty heavy discussion. And as Americans, we the people give our government a great deal of power in order to protect our national security. And these include the authority to collect some very sensitive information and to keep it secret. And we have laws, including criminal penalties, to make sure that secret stays secret when lives are definitely on the line. What I'm describing is how it's all supposed to work. Government actors are given significant power and tools that they're supposed to use to keep us safe. They're given the weighty responsibility of keeping information so secret so nothing gets out that could actually put lives at risk. But inevitably, there will be times when classified information is leaked to the press. We all know that. And in these moments, it can be hard to tell a brave whistleblower from an unpatriotic criminal. And it's often only in the writing of history that we actually will be able to say whether or not a leak was in the public interest or a serious threat to our national security. And so we have a complex set of tools and laws, and ultimately courts are tasked with getting this careful balance just right. The right of pursuing justice, protecting our national security, and also protecting the free press that is foundational to our democracy. So the question before us is whether that system is really working right now, or is it in need of repair? So one element of this system is the SHIELD laws, state laws that allow reporters and editors and others to protect their sources. At least 40 states in the District of Columbia have some form of SHIELD law on the books, including the state that I represent, which is Georgia. And I'm going to direct these questions to either Ms. Burton or Ms. Oberlander. Both of you, please feel free to jump in. Do these state laws vary in their approach to providing reporters protection from compelled disclosure? And also, to the extent that they do vary, has the state-by-state approach adequately protected our journalists that have been engaged in First Amendment activities?
Well, they do vary, as I previously mentioned. Some states have a qualified privilege for everything, where you have to go through some sort of balancing test before you can get it. Some states have a absolute privilege for, most places don't have an absolute privilege for everything, including, but for confidential sources, they might protect that absolutely. And there are variations, but they do all provide some level. Well, most of them provide some level of protection. The federal circuits as well have different standards, and again, so you can completely depend on what circuit you're in as to what is the standard you have to prove. So all of them, the fact that there are these varying standards creates great uncertainty on the part of the journalists and of the people who want to provide them information. To your point about national security, though, and to the degree that there is a investigation into some type of leak or some other type of national security search, it would probably be under the federal, it would probably come out of a federal court, if not always, and then you would be faced with the question of which circuit you're in, and again, those standards do vary.
Okay, thank you. And Ms. Burton, did you want to respond?
Yeah, I wanted to respond to your first comment, which I think is very important regarding the balancing of national security interests, because we haven't really spoken about that. The Pentagon Papers case, again, 50 years today, makes notice of that, where you had a judge who was told that national security would result in the killing of many troops. And he took a very strong look at all of the information and then determined that, well, he couldn't be sure, that he had to balance against other rights, which in this instance were the press rights. And so that balancing, and courts that really look at these things carefully, whether it's in the SHIELD law or national security, that's kind of the best you can get. There's lots of facts, there's a patchwork of statutes. We have to rely on the judiciary to do their job properly, and we have to require it of them. So I would say, on the state SHIELD laws, we could use a federal privilege on that. And I think that's the way in which you would begin to smooth it. But every state is different, and it's very much a patchwork at this point.
But thank you so much. And I'm about out of time, but I want to thank both of you for really giving us good detailed answers for these questions. And I yield back the balance of my time.
Gentlelady yields back. Ms. Escobar. Thank you, Mr. Chairman, and many thanks to our panelists for being here today and for